Okay, good evening everyone and welcome to Thursday evening's online seminar. Today we are looking at contract termination, which is Richard Silver's hot topic for today. Richard is the senior partner at Silver Shemmings with many years of experience across the construction industry, so we look forward to hearing from him. So without any further ado, Richard, over to you. The floor is yours.
Thank you, Julie. Good afternoon, all. Many of you will know me. I act both as an adjudicator, arbitrator, mediator, conciliator, but also as a party representative. At the present moment, I have a number of disputes, either acting as representative or as adjudicator, and a number of them do involve the issue of determination. It seems with the current climate, the issue of determination is becoming a hot one. I can understand why. People may have entered into contracts where they no longer want to complete the works, or it may be the case that people aren't performing and they want to get rid of them. There are a number of factors which may lead to issues on determination, and therefore I thought it was prudent to try and cover that in the course today. I've produced some slides. The start is that in order to be able to terminate, there must be obviously a contract in place, and unless that contract provides for termination at will, the reason why someone will seek to terminate is because there has been some form of breach. The question is, what nature of breach are you able to terminate? Or indeed, I suppose the starting point is what is a breach? And a breach is anything that a party is meant to do, but hasn't, or anything that a party has done, which they shouldn't. And from my own experience, when I used to work in construction, we were in breach every day. We didn't send notice of extensions of time when we should have done, as soon as they became reasonably apparent. We didn't always ask for information and comply with the drawings. There's loads of things we didn't do. We didn't do the works to their perfect standard. There were defects, there were snags. All these things are breaches. However, when you're seeking to terminate under a contract, you can only terminate where it is a fundamental term of that contract. It is, in other words, a condition. Now, do not get confused when you read that a contract says these are the conditions of contract, because it is not the case that every one of those terms will be a fundamental term. Now, the situation is that you have certain terms which are called warranties. They aren't fundamental. They don't go to the very heart of the contract. We then have certain terms that are considered to be conditions. They are deemed to be fundamentally important. And the courts have recognized that sometimes a particular term might not be so important at one stage, but can come very important later on. So a prime example is progress. You are 1 day behind. I would suggest to you that you are not in breach of a condition. You are 1 year behind and not got anybody on site, you are in breach of a condition. So what they call these middle terms are innominate or intermediate terms. And what we need to determine is whether a term is a condition, fundamental, or simply a warranty. What I've got here is some examples of what are or have been considered to be fundamental terms. And the starting point is the first bullet point, where basically the contractor is unable to carry out the works for, by way of example, a failure to give access to site and possession. Now, JCT, by way of example, acknowledges this possibility and provides for deferred possession. So whenever trying to determine whether there's a breach of condition, you need to look at the particular terms to see how it deals with it. But generally, sooner or later, a failure to give possession of the site will result in a breach of a condition allowing termination. And by way of example, JCT expressly provides that where the works are suspended for such and such a period of time, there is a right to terminate. A clear, unjustified order not to complete the works is a repudiation as well. And this is one that often comes up. You have placed an order with a contractor to carry out the works, and they've got a right to carry out those works and be paid for them. If you choose to take all those works away and give them to somebody else, you are showing you no longer want to be bound by the contract. You have breached a condition. Now, do be aware, again, I refer to JCT, it says that you can omit works. So you can take works away from the contractor, but it doesn't say omit works and give them to somebody else. So where there is an order placed with somebody, you cannot take that work away from them and give it to others generally, unless your contract expressly provides for it. So there has been much case law where work has been taken away from one party and given to another, and that has been considered a repudiatory breach, allowing the other party to terminate. The engagement of contractors to execute the same works already contracted to another, we mentioned that one. One other thing is taking works away from somebody and seeking to contracharge them. So, for example, you're on a contract and a contractor is failing to proceed regularly and diligently. You decide, and I've seen it often done, that what you're going to do is to supplement their labour. We're going to get another contractor on site, we'll get that work completed, and we will charge the costs so incurred against the original contractor. Again, unless the contract expressly provides and allows you to do that, you can't. And thereby taking the work away from them and employing others will be a repudiatory breach, allowing termination. So do be careful. So if you want to have the right either to take works away from someone and give it to others, or to employ others and to charge the costs so incurred against the original contractor, you can only do that if the contract expressly provides for it. If it doesn't, you can't do it, and it will be a repudiatory breach, a breach of a fundamental term, the breach of a condition. For those of you who are contractors, quite often believe that a failure to pay is a breach of condition, where the employer doesn't pay you. But the situation is the simple fact that an employer doesn't pay you doesn't mean that they don't want to continue in the contract. They may not pay you for a number of reasons. In particular, they don't agree with what you're entitled to. So simply not paying one amount or even one certificate, or what is stated to be the payment notice, where there's been no pay less notice or your application, does not generally mean they have breached a condition. Where it is towards the latter part of the contract, it is more likely to be seen as a breach of condition, or where there continues to be a failure to pay, then that too has been found to be a breach of condition. But in all circumstances, you'll need to look at the contract and also determine when it's not being paid in the contract period, for how long, and what was the intention, what was the reason for not paying. The bullet point at the bottom, abandonment of the site. Now, many of you hopefully are aware that under the contract, following the Housing Grants Act, any party who is not paid the amount due to them by the final date for payment is entitled to issue a 7-day letter of their intention to suspend. So, monies are properly due by reason of either your application and where there's no payment notice or pay less notice, or where there's been a payment notice or no pay less notice, Once those monies have not been paid by the final date for payment, you can issue a 7-day notice of intention to suspend. And when the 7 days have elapsed, you can suspend. But if you have not issued that notice, you have no right to suspend. And if you do suspend, you have committed a repudiation, a breach of a condition, allowing the other party to terminate. Equally, if you remove sites, if you give by your actions an indication that you no longer want to carry out the works, that is a breach of a condition. One of the ones that always comes up far more than any others is the allegation that a party is failing to proceed with due diligence. And if that is the case, if you then give them notice and they fail to rectify their breach, you are allowed to terminate. But the big problem is trying to establish whether they've failed to proceed with due diligence. If there's no work on site, then it's fairly easy to establish. But where they are proceeding, they're just rubbish, that isn't necessarily failing to proceed with due diligence. What you'll need to do is to establish what they need to do to complete by the completion date. But do remember, the contract provides for liquidated damages, so it recognises that the contractor may not complete by the completion date. So what this shows is that you cannot, or not sensibly, seek to determine at the beginning of the job, because the contractor can always seek to argue to say, I can still complete by the completion date. As you get closer to the proposed completion date, the right to terminate for failure to complete with due diligence is far easier. If there is a short period of time that is left and the works are substantially incomplete and you keep sending notices and they're not proceeding, then it's likely to be able to be shown that they're failing to proceed with due diligence. But it is a dangerous area. Final bullet point at the bottom of that page is where there is defective work and the party has advised of that defective work and has requested it to be rectified, and there is a failure to rectify that defect, and this causes follow-on trades being unable to proceed with their works, the party is effectively showing that they are not willing to comply with the contract. They are thereby seen to breaching a condition, and there is a right to terminate. So what we've done in the first set is to show actions, one-off actions, that effectively can show you can terminate. However, there is a further circumstance where the party has done so many small things, it's quite clear they're incapable of ever completing. So if you've got a project and they're progressing on site, but there are just so many defects, and every time they complete something, there's something wrong with it, and you actually look at it and say, being perfectly honest, I don't think you could ever complete this job. You're just not capable. They're thereby in breach of a condition, and there is a right to terminate. The next one is where a party does something by their actions indicating they no longer want to be bound by that contract. As the slide shows, these are called anticipatory breaches. So let's give an example. You obtain a quotation from a subcontractor and you then simply accept that tender. There is now a contract in place. The subcontractor then decides that they no longer want to carry out that job for whatever reason. Maybe they've picked up another job, they've got other concerns, but they've got a contract placed with them to undertake the works. Will they go to the employing party and say, we are not going to carry out the works, even though the works weren't due to start yet? They have committed an anticipatory breach. They have advised the other party that they do not intend to carry out the works, and which would allow the party to terminate. What I have identified so far is that termination is a very difficult area. When I first started in construction, many years ago, it was on the construction of a large sports centre in Cheshunt. I had just finished my degree and was on site. And at the time, we were having all the brickwork constructed. And to be honest, the brickwork was shocking. The cavities were far too wide, so the cavity ties couldn't hit each skin. There were no cavity baps. The lintels didn't fit. The works were shocking. My contracts manager at that time sought to terminate under what was a JCT contract. And basically, he failed to terminate properly because he did not give the right to put the work right. And as a consequence, by his actions, he'd committed a repudiatory breach, and the brickwork subcontractor accepted it. We all went off to court and we lost, and the subcontractor got payment in damages. To seek to overcome that problem, many contracts set down within them what conditions are a condition. In other words, which terms are fundamental. And they say that this is a fundamental term, and thereby if you breach it, you are entitled to terminate. But when looking to establish whether it is a fundamental term, you have to look at the wording of the contract. And you can see in certain contracts, they say things of the essence. That indicates that it is a condition. But in determining whether or not it is of the essence, it is a condition, you need to look at the whole contract. If I put time is of the essence, in other words, you must complete on time, yet I also have provisions for liquidated damages for late completion, those two provisions don't seem to gel together. How can time be of the essence, yet you've allowed me to finish late, but I have to pay liquidated damages? So the courts will look at all the terms to determine whether or not the terms are conditions. JCT, NEC, other standard forms often put express provisions for termination. They try and move away from what is the common law position. What I've gone through just previously is all common law. It is case law. Now, to try and make it clearer and to the benefit of the parties and why JCT NEC produce contracts is to provide clarity. They set down within them what the situation is with regards to termination. This is obviously of benefit to both parties because it gets rid of uncertainty. But do be aware, by way of example in the JCT, it expressly states that your common law rights are retained. In other words, you can possibly terminate under the conditions of the contract with effect that the contract remains in place, but the employment is terminated, or you can terminate under the common law with effect the whole contract is brought to an end. And I will explain on one of the slides a little later what the difference is and what the benefits of one over the other is. When we're dealing with the common law and the breach of a condition, a repudiatory breach, the party has a choice. They can either elect to accept the repudiation and thereby bring the contract to an end, or they can do what is called to affirm the contract, and in effect saying we will not bring the contract to an end, and you have continuing obligations to complete the works. So you have two options. Let's just make this very clear. Where a party has committed a repudiatory breach, the other party has to elect. They either accept to affirm the contract and keep the contract in place, or they elect to bring the contract to an end. And to determine which one has happened, there needs to be a clear and prompt election. You have to show clearly by your actions what of the two options you are taking. And it has to be very clear. In order to affirm the contract, in other words, to accept the repudiation, the innocent party must have, first of all, known of the breach, and second, his legal right to choose. And that may not be immediately, that can go on for some time. So in other words, if I commit a repudiatory breach today, it may take some time for the other party to decide which of the two options open to him is going to take. He has to know, first of all, of my breach, and then he must know of what his rights are. Once the party knows of the breach and the right to terminate, he can either elect to accept the termination or to affirm the contract by word written or by his actions. So it doesn't necessarily have to be by a written letter, but if you do something which shows that you want to do one of the two options, that then will have the effect of either bringing the contract to an end or affirming the contract. But if a party simply says, I want you to complete the works, does not necessarily mean that they're affirming the contract. All they're doing is seeking to confirm what is the obligation of the contract originally. They have not given away their right to terminate. And let's be honest, on a construction contract, if a contractor is failing to perform, you're going to keep asking them to carry out the works. You're going to demand that they're carrying out the works, but you're not indicating that you're going to forego your right to terminate. You're just confirming what you want to be done. And at some stage later, you may still choose to terminate if they do not carry out the works effectively. As this slide says, in order to accept repudiation, it must be clear and unequivocal. Simply the fact that you delay is not going to be sufficient. So let's just summarize where we are so far. In order to terminate, you can either terminate under the contract or at common law. When at common law, it must be a fundamental breach of contract. Once that fundamental breach of contract occurs, you have a right to elect to accept, either to affirm the contract, to keep the contract in place, or to elect to accept the repudiation and bring the contract to an end. You will only deem to have made your choice when you first know of the breach, and second of all, when you know that you have that legal entitlement. By simply calling for the works to be complete is not making your decision. Your decision must be by your actions showing which one you have done, or by word. Once you've done it, you are bound by that position. As an adjudicator, I never, ever have one party accepting that the other party has breached the contract and therefore there was a right to terminate. What always happens is each of the parties blames the others. They both say that the other has repudiated the contract and that they therefore have the right to terminate. We all know only too well that if you've wrongfully breached the contract, allowing the other party to terminate, they're entitled to damages. And we all want the damages. We don't want to pay out damages. So there is always an argument as to which party has terminated. And where there is a situation that both parties have done a breach that could allow termination, it is generally the situation that whichever party committed the breach first had the right to terminate. So it's not the party who accepts the termination that applies, it is whoever has breached the contract first. So, what are the effects if there has been a termination? There are two key consequences of a termination. The first situation is that the innocent party has no more obligations under the original contract. So let's give an example. A contract has been placed with a contractor to carry out certain works. The employer, let's just say because of a failure to pay, has committed a repudiation which the contractor has elected to accept. The contractor no longer has any obligation to complete the outstanding works. But also, the contractor has no obligation to rectify outstanding defects in those works, because his obligation under that contract has come to an end. That can be a major benefit. The second result of termination is the innocent party is entitled to damages. And one of the questions that was raised before the course was started and sent to Julie is, what are you entitled to recover? And the simple answer is that you are entitled to recover those losses you've incurred that you would not have incurred had you been allowed to complete the works. Damages is not an attempt to obtain greater profits. It is to recompense you. Clearly, if you'd been allowed to complete the works, you may have had profit on the outstanding works. So you'd be able to recover that. You can recover any losses that you can show to have been incurred as a direct result of the repudiation and resulting termination. Now, I mentioned about the no longer having the ability to rectify works. That doesn't mean you'll get paid for defective works. What will effectively happen is the works, as to their value, will be abated, taking account the defects within them. One thing that often people ask is, where the contract terminates, there can be nothing left. Well, no, there are still certain rights. One of them particularly being the right to go to arbitration and litigation. Quite often, the disputes that arise actually relate to which party has terminated. Other rights are retained which exist before the termination. So, unless the contract otherwise states, if there's monies owed to the contractor prior to termination, subject to the terms and conditions, those monies can be recovered. Similarly, if there is a right for liquidated damages prior to termination, provided the contract so provides, those can be recovered relating to the period prior to the termination. But it will all depend very much upon the provisions of the contract. Now, I'm quickly going to turn to certain terms that are included in contracts about termination. And one of them is that generally termination should not be carried out which is unreasonable or vexatious. And where vexatious has been looked into, they've identified that it's an ulterior motive to oppress, harass, or annoy. It isn't because it is in one party's best interest, but it is to actually upset and annoy the other party. So if you're going to do it vexatiously, then that termination will not be effective. It says in a number of terms, contracts, without prejudice to any other rights and remedies. What that is doing is particularly recognising that your common law rights are retained. One thing I would say is, if you're going to terminate under clauses in the standard forms, do it properly and exactly what the contract says. Generally, most contracts have two notices. The first is in effect a warning notice. It says something like this: you give the other party notice of the specified defaults, and they are given 7 days in which to rectify them. And it may say that you have to issue that notice by recorded delivery. My advice to you is very simple. If it says you must deliver it on a Wednesday with a red hat, that's what you do. Do what the contract says. So if it says you have to issue the first notice on is the first day, and the second notice you have to issue 7 days later, make sure you do it. If it says that it's got to be issued by recorded delivery, make sure you do it. Where there is two notices and you've issued the first notice and things have improved, and then 6 months later the problems reoccur, do not rely upon your original notice. Reissue the first notice and then the second notice. As far as the content of the notices are concerned, again, I would recommend that you repeat what the contract says. Now, where the contract has a number of grounds for termination, I see no harm in referring to more than one ground. But make sure you'll be able to prove that failure, that ground. Now, what often happens is a party seeks to terminate. They think they have rights to terminate, but they don't. By seeking to terminate when you didn't have the grounds to do so is in itself a repudiation. You are showing that you are no longer willing to comply with the contract. You've sought to terminate the contract when you're not allowed to. You've, in other words, had a fundamental breach. You fundamentally caused these works not to be completed, and as such, you've committed a repudiatory breach which the other party can elect to accept. And that's what always happens. Whenever one party seeks to terminate, the other party always argues that it was the other party who've committed the breach and they themselves have terminated. Where you have given a reason to terminate under the common law and that reason is wrong, you can nevertheless rely upon a different reason if you find one exists. A bit surprising, but that's what the case law says. Final thing is to explain why a party would seek to terminate under the contract, ideally, rather than common law, and why sometimes under the common law may be in your best interest. So the starting point is, under all contracts, where you terminate under the express provisions in the contract, it sets down what happens thereafter. For example, a number of contracts say you don't have to pay the other party any monies until, for example, practical completion, and when that's achieved by the employment of others. That can be a major benefit. I don't have to pay you anything. I know I hold money is on account from you. You did the last application, I haven't paid it. I've terminated, you're not entitled to any more monies, you're not entitled to your retention, nothing else. And withhold all those monies until I have completed all the works. That can be a major benefit. There are other provisions like you can use the plant that's retained on site. So you may well be in a much stronger position to terminate under the contract and have the contract provisions that follow termination continuing to apply. However, under most contracts, you have to issue 2 notices, and that takes time. And sometimes you just simply don't have the time. And therefore, it can be much easier and beneficial to terminate under the common law, because it happens immediately and the contract provisions are go, and you can then deal with the final account and other actions immediately. So it is very careful, do be very careful in trying to decide which is the best option. Now, I'm a belt and braces sort of person, and therefore, when I seek to terminate, quite often I will seek to terminate under the contract and then put further in the alternative, if there is any reason I can't terminate under the contract, I seek to terminate under the common law. Okay, I see that there are some questions. Let's see.
There are indeed, Richard.
Sorry?
I said there are indeed. Okay, if you terminate a subcontractor's contract during the works, are there liabilities for warranties, stroke defects discharged from works they have completed?
Okay. And the answer to that one is it depends upon A, the contract, and B, the way you have terminated. Where you have terminated under the common law, neither party has any further obligations to carry out any more works. So the requirement to provide warranties and otherwise all disappears. And what happens instead is the innocent party is entitled to damages, and which would include all the additional costs that have been incurred by reason of the termination. Now, clearly, if the subcontractor chooses still to issue that information, then the losses incurred by the innocent party are reduced. But once the contract is terminated on common law, you cannot seek to force the other party to do anything. Where you are terminated under the contract, however, it depends on what the contract says. And the contract may require, if there are provisions to that effect, that they provide whatever documentation that they have to the innocent party. But let's be honest, where you've terminated, generally the relationships have soured, to say the very least, and it's unlikely you're going to get anything back. The only way of getting something more back is to show that if that information is not provided, the innocent party is entitled to the cost they will incur in obtaining that information from another source. I hope that answers that question.
Lovely. One of the question we had pre-submitted as well had actually had two parts to it. I'm not sure we dealt with the second part, which is obviously the main question was in the event of termination made by an employer. It says, once it's terminated, can an employer start his project with another contractor by changing the design of the original work, since it changes the nature of the original work?
I think the question is alluding to two separate things. So number one is where the contract has been terminated, the obligations with that other party have come to an end. So yes, you can seek to employ someone else to carry out those works. Now, if you, however, choose that the works that you're going to undertake are to be different, you cannot seek to recover all the costs that you so incur, because the cost you have incurred may include betterment. And what you often find is the claim for damages following termination becomes many things that aren't included in the original works. All the innocent party is entitled to recover is the loss they've caused to be incurred by reason of the breach. So in other words, if the works are defective, the costs of repair. If they were to undertake something and they would have paid them £5,000 to do it, but they now got to employ somebody else and it's going to cost £10,000, they can claim the difference. But what they can't claim is £20,000 for doing something completely different. So where there is a change of design, if there is going to be a claim for damages, they will need to show what they would have incurred had they carried out the works as per the original design.
Right. Okay, that clarifies that beautifully. I think that's the end of our questions, unless anyone has anything else that they need to know. Otherwise, as with all of these, if there's anything specific or an issue specific you'd like to raise with Richard you didn't want to do today, his email address is on our website. It's on the slides which are now available for you, and it'll also be on the video recording of this, which will be available tomorrow and all over the website. But for info, it's Richard Silver at silverllp.com, and he'll be happy to answer any specifics for you at all on this topic. So thank you everyone very much for listening. Thank you, Richard, for sharing your expertise with us. And we hope to see you all again soon, and stay safe, everyone. So thank you and good evening.
I would just add one final thing is I think the next one we're doing is contract formation.
It is.
If there was any course I would strongly recommend everybody attend, it's that one. Nearly every dispute I get involved with involves issues concerning contract formation, and it is possibly, in my view, one of the major problems on all projects. So I would very much recommend that you attend the next course. But thank you for listening, and I hope you found it useful.
No problem. Thanks, Richard. We'll speak to you soon. Thank you, everyone. Good night.